nsem ne yenye free court se ne wo ho de ye sanso akoye chika kra na afei ye ma me Chief Justice Gertrude Araba Esaba Saki tokonum yako na kachi ebio na nsem ya enam so ma enne binom prese ye ntu no ade so efri di bra wokura na ebi so ese wo mo enfo aso no enam so ema mra hyebedweni Old Tafo abaton person so nmunyam for Vincent kwasefo edna no aba betum ebi a wo kire se legal team a wonom ata echire na wom area se proceedings ne betumi atwentwen so kakra no e na wo kire mu se ne ebre pemu no wo mo besan so ababio na ba wom besan so aba no na e wo se wo mo etwentwen so na de enti o kire so mo twentwen so no nyina ne se asem mo tabri mu erikokopie mu e wo court no Supreme Court area ebo asem no e de etugui no mo ne nsentwerofo enso eye nhyiemu kakra e wo e na wonmonyam for Vincent ekọ asefo a wo de etudwa e na wo kire mu ese ne entre nam so ntra wo press suspension no ne nyina no wo mo hu ne se Supreme Court ruling no e ba ye ne nyina no kamia kwa se enye no ano no wo mo se enye no e na be ma asem ne nyina etu etwa enye the end of the legal road eno no eno nti se sia na court akasa no mo twen se me busumi emu ene da etoso eduonu ba ko 21st May 2025 no and the omunya details ni bibia ne nam so ntra e ma ruling no e ba ye no a na afi wo ma to so e de efiri wo no mo eno nti e na wo kire mu ese enye no ano no enkonkosi wo no mo a ebi e wo ekire a e wo se tumi e ba na no de wo mo twen se 21st May ekire no na wo mo e de ho nsem aba yentie se de no so wo kire mu e fine
the impulse of the reasoning behind the ruling, and maybe from there we'll be able to decide as to the next course of action.
So you wouldn't say this is the end of the road?
Well, but let's just get the reasoning first. When we get the reasoning, of course, the 3-2 ruling suggests that the Supreme Court itself sees some reasoning in the arguments that we made in court. It tells you that our argument or the reasoning that we advanced in court was quite potent. And so let's get the reasoning, and when we're able to get the reasoning, we'll be able to decide what we intend to do after assessing the reasoning.
What do you make of the fact that
because Tufo versus Attorney General clearly tells you that in reading the Constitution, you have to do so by the letter and the spirit. If anybody tells you that because something has not been clearly stated in the Constitution, and for that matter, it has no potency, I am telling you that that is not the case. In fact, even today, the Interpretation Act of Ghana tells you that we have to read the Constitution purposively. Purposively means that the letter and the context is very much important. It is on that basis that even the Geawu case, where a prima facie that will have to be established in the case of a Chief Justice, which has not been stated clearly in the Constitution. Geawu said that we have to establish a prima facie. So if anybody tells you that something will have to be stated in the Constitution before some potency will have to be given to it, I don't think that is the law. Let's wait for the reasoning and see what we can do.
Are you disappointed?
When for Vincent Asefo and Enwechi and a former Attorney General and Minister for Justice. When for Godfrey Yabua Dame and so and Etumu bin watch say, Niaka Connedia and Geawu Kakaka na will arrest you so say in Kunimudi, Ebaya Wamudia. Charlie.
Your initial reaction to this particular ruling?
Well, I think that I find it quite intriguing to start with that the acting Chief Justice himself decided to proceedings, and as I indicated, I find it very incongruous because indeed, if at all there's any beneficiary from all of each involvement, and the acting Chief Justice is the direct beneficiary of this. Of course, it's a constitutional injunction for him to act as the next procedure, but clearly we cannot lose sight of the fact that whatever has happened, the benefit of it accrues to him. And it is incongruous in the constitutional history of this country. We've never seen any development like that before. Whenever there has been a dispute as to the status of the Chief Justice in this country, start from 1980 before the Attorney General, start from 1983, 94, Aban, and we go to 2005, there about Geawu and all. The Chief Justice in question panel the court, but never sat on the matter. I mean, so it cannot be right for the acting Chief Justice to sit on the matter. But that's it. We see the 3-2 ruling, very narrow decision. wait for the reasons. When the reasons come, we'll definitely advise ourselves. The narrowness of the petition itself indicates clearly that the application no doubt had merit and will know what to do. All right?
You're being like the president's failure to notify the Chief Justice from the outset constitutes an egregious constitutional violation. But one of the panel members pressed you. He wanted you to point the panel to the clause in Article 146.
Had not been known. Of course, clearly, I mean, the spirit of Article 146 we're talking about. In the first place, it is important to indicate that nowhere in Article 146 will you find the requirement for prima facie intervention made for a Chief Justice. But the Supreme Court itself imported that into Article 146 in 2005 when it adjudicated on the adjudication matter. But of course, the Supreme Court was silent on whether there ought to be notification to the Chief Justice and obtaining of his comment before triggering the process. And that is what is in this week before the court. My contention is that natural justice, all the rules of constitutionalism and all will require that there ought to be such process before Article 146 can be triggered. Thank you very much.
A former Attorney General and Minister for Justice, Onmonyan for Godfred Yeboah Dame, and the Krakremu and a Deputy Attorney General, Dr. Justice Rem, and so they are etwaso, Kakrebi on also the count in him.
I get to see the reasoning. So when we see the reasoning, of course, then we will know whether the court using dissented, the justice dissented or dissenting, there was any basis for it. There are so many reasons why the court dissented, but you were in court and you realize that the question was consistently put. What exactly are you alleging? What is the right that you are alleging? And to pile up a series of newspaper publications claiming that because newspapers are published that the president is attacking the judiciary, that is enough for the president to stop the process. So the process is unconstitutional because newspapers are published. That cannot be a very strong legal basis. And when you saw the attachments of newspaper publications, many of them, I don't think that publication is a legal right or determines the legal right for anyone.
Okay, so for the decision that has been taken today, what does it mean to the process that is currently before the committee that is supposed to be?
Well, it means the process will go on. The process will go on. The committee would sit, would hear the inquiry into the matter. And of course, I have always maintained that the finding of prima facie is not automatic that the Chief Justice or the person who is being who is the subject matter of the petition has been removed. It is not at all. So it may come out that the Chief Justice, the petition has not been of merit, and the Chief Justice will be restored to her position. I am always surprised that people have concluded that the fact that prima facie is found and means that the Chief Justice automatically removed from office. You see, that is what actually motivates this petition, this motion that have been filed. I think the underlying understanding, which I consider a misunderstanding, is that the plaintiff believe that when the prima facie case is established, then it's a gone issue. But it is not. The court really confirms what we have been saying all this while, that there is no legitimate, legal, or constitutional basis for all these processes that the former Attorney General has filed on behalf of Honorable Asif. Today you notice that even injunction, they had 2 injunctions on the record. And they were asked, when they were asked, they quickly withdrew one, which is clearly an abuse of the court process. To keep filing processes with hope that one of them will stand is really not a good practice for a lawyer to do. But that is what happened. And as you follow the arguments, the court have been insistent that what exactly is your concern? The right to claim to have been abused actually have not been abused because the Chief Justice was given a hearing. And there's no legal provision which dictates what time in the process of the hearing. So if you ask me, every issue is stand on no solid ground. And that is why I agree with the court that this is what the right way to do.
But 3-2 majority means that the court was not.
Way a deputy attorney general enka ena yete ye no court nsemo a yeda so ewo mu ye behwe na fei ye nuaba mabra kwampo for the ewie kra say former secretary officer ewo eye interministerial committee on illegal mining eho Charles onua wonto bisiu ena afei Andy Thomas Owusu sabre ameno eka say sikabotine de ahwe wor masum 400,000 Ghana cedis I no with two sureties I was say no so no munya japade ene enkramante mu ase japade e betumi ahye asom sase kabotini enti waba o mai eso de bibia fa kwotun de ene nyina egu ne sere so a wode eho amanebo e de eba ama brako ampof wadaroma kwotun asemi asabre 400,000 Ghana cedis ye de abo wonua wonto bisiu ena afei Andy Thomas Owusu no wadaroma boyemu kakra
Yɛnkyɛn ni sɛ ɛna ɛyɛ high court now. Na a case we office of the special prosecutor Odunyamfo Kisi Ajabe ɛna ɛde ɛkɔpie mu ɛwɔ court. Ne nyinaa ɛyɛ inter-ministerial committee on illegal mining na ɛbere bi yɛ pass committee no. Na ɛno ɛne first time koraa ɛne yɛde enipa mmienu ɛyɛ Charles Onya wonto bisiu any Andy Thomas ebepie mu court kwadu mako edunu 15 charges and as a count and yedi abon na omummienu ni nyina obi eni wa oje ne mfom so atwum oma lawyer estre court ni say ye na omubill san say ye ka Charles Onya wonto bisiu a obi eni mu no obi eni na kwala ketu akra obodi a onim no nti sepa say ye ma ni bill na no ena ya ade a eye OSP a lawyer for so oma oppose kra omo chese omo ni ha obi as a court e be man bail na mum abesedi a omo de beto court na nim ni say court no enye ni such a way say our passport or the passport ba the to court o tu kwan a oma court ni hu ansa na we tu kwan isan say bebebre omo bail o si me kwa ma no ni aba okwa eno anu no e di esipen eno ena otemuafo ma me comfort tasia me eti asabe say office of the special prosecutor lawyer for ese omo opposite dia obema on bill onipa ba ko bia ofiase efi Charles onua wonto bisiu oma no eye 200,000 Ghana cedis bill enipa bienu enyina na chi security enipa bienu no ese mu ba ko ewe gapade a esom 200,000 Ghana cedis e won kran ha the Japadian Enyaka or still landed property, Ewo and Kaha. A can landed property, many other Ayasase, any a dime a day, and never meaning. And when you court say, Bosumi be a daba on fire and watch a office of the special prosecutor, investigator on your case. And when she the passport of a metal court registry or you're not used to be too quiet. On chocolate cracker and family court no. Now on chair court no say we took the quack we the quack never say that court na dream no shame never ya no man kwansa onko court ni we no call ora Andy Thomas Owusu so and I say Andy also sika me dey too so 200,000 Ghana cedis for nipa me no gina wachi nipa me no gina wachi e mu baako e so no so we gapade e won kramantam ha a landed property and one some say also a passport for the court ha Bosumi bia e daba ko fa won chere eye OSP investigator ono eye nhwemu court ni we ni sabe no se osere alaya for ejina edi ama office of the special prosecutor no omo na eye se osere mo pa omo file disclosures ngate bi ahunya so be use no omo file omo wi a omo serve eye Charles Onya wonto ena ora Andy court na tu asem no e dia shembe Bosumi ni de so May 29 ese yamfa umra media ebra ye court one there na bill conditions no omuntini nitiye me wo ena office of the special prosecutor investigators no ekofa car ebesi abonti on say omo ya arrangement na ye de wo ma besia akọ eni edwane de question Supreme Court as to say omuntini niti bill conditions ni ekofie ne de media isi eno eye nkomafofra ye negusu di echi otra ebebo echi na say omo niti bill conditions ni ko ana say omada ebia OSP akache amade achi nti obisaya say NC e wo court ni
Where the one who yada se papa any enchiremwa wode ama yen. Ebusua yenuaba ama brako ampofo ene edutri enkome ba no court nsemo a wono ene hema ene ye wodi ehim ni aham e wo court dem saa internet Charles Bisu wonya 200,000 Ghana cedis ena fei Andy Thomas owusunsu 200,000 Ghana cedis into kambomu a 400,000 Ghana cedis ena sabre no ya chede ama wo mo a with two sureties e wo se mu baako e wo landed property say ya asase ye dan ye park ni nyina ya asase ya eno esom 200,000 Ghana cedis to the free court aba ebi eno no